Hi everyone, I'm Ozan Redjep. I'm joined today by planning consultant David Kemp from DRK Planning. David,
Hi,
welcome to the video.
Hi.
Thank you for making the time. You're a very busy man. You've been travelling the world, and I know you're really busy, so thank you very much for making the time. Today we're covering 3 common mistakes that you see day to day in property development. So do you want to kick us off with number 1?
Yeah, I think one of the issues that often comes up is that when vendors are they're advertising their sites and they've got an agent involved, and the agent wants to look for as much as they possibly can for the deal, then they obviously sometimes advertise it with a potential for a planning gain there. As I'm dealing with a couple of bids at the moment where the agents have either said we've put in for an allocation for X number of units within the local plan, or they've got a permitted development or prior approval application running at the moment, and therefore say that off the back of that there will be permission for X number of units. And the other one is where they feel that there's the potential for planning gain for, say, up to 20, 30, 40, 50 units in terms of extra building on the site. Because quite simply, all they've done is they've looked at the site plan and said within that site there's potential for another few buildings on that site. And in short, never trust the agent. just check absolutely everything. And actually, as one particular example, there's one that I'm looking at with a potential development partner at the moment, where the site is being advertised for potential for in excess of 200 units through redevelopment by submission to the local plan. I called up the council and they said, well, actually most of the site is in Greenbelt and we've got no intention of letting go of the Greenbelt in this particular area, and therefore we think we would probably be against it in principle because of Greenbelt, and also because it's a landscape character area as well. So that kind of knocked that one on the head. The next one that the agent was saying is, well, even if there wasn't an allocation for that, we think there would be the potential for another 50 units on the site in terms of new build. The officer again said pretty much the same thing. Well, we think it would probably be against, we'd be against it in principle. So that again came up. Bear in mind with all of these things, we're not saying that they would never get planning permission, but obviously you have to take a view with regards to then going forwards to investors and saying, well, if you're going to put money into this deal, what is a sensible level at which to put the money in terms of the basis of the figures. And even to the point that they actually have a prior approval already for X number of units, then they want to add another 20 or so units, and they've got a current prior approval application running. And
they want to increase the density.
So they're increasing the density. There are problems even with that current prior approval, because one of the things that you has to check in some applications, and this comes up a lot with applications down in the southeast where they interfere with natural heathland and upland, there is a parallel regime that happens with prior approval applications and office to resi schemes, in that sometimes you have to make a financial contribution before you can actually occupy and implement the development. That contribution goes to Natural England or to the council in order to deal with the problem of people using heathland or upland as well. It's quite a complicated area. It's to do with natural habitats regulations and conservation regulations as well.
Is this what we hear about a lot? SANG's land, is that
SANG, yeah, sites of alternative natural green space.
Yeah.
And basically what it means is that the council can grant prior approval, but you won't be able to implement it and occupy it unless you've got Natural England's consent. And in this particular case, there were 2 prior approval applications on this site that we're looking at. One has been granted. Natural England did not object to that one. They have objected to the second one. So that means that at the very least we need to take into account roughly in the region of about £40,000 of additional financial contributions on the site.
Is there also an issue, apart from the 40k in that example, of additional costs that wasn't initially considered to be part of the calculation? Is there also an issue that there's not always enough of this type of land? So sometimes finding the land can be an issue as well.
That's right.
Even if you're willing to pay for it.
That's right. And sometimes it's not just a matter of just paying money and throwing money at the problem, because Natural England and the council have to agree that is the appropriate solution in that case. There has to be a certain amount of space which is available for developments, new developments, to be allocated their alternative natural green space within a pool of natural green space within the area, alternative natural green space in the area. And if the council don't have enough alternative natural green space to allocate to the extra units in the development, then no amount of money thrown at the problem is going to help, and the council just simply won't be able to grant planning permission for it unless they get a fresh allocation from another area or another plot of land. So there are often latent problems which, quite unsurprisingly, the agents won't be alluding to, and you just need to check absolutely everything. Otherwise you can really land yourself in a hole once you've obtained the site, once you've committed yourself to the deal, and then you find all these problems further down the line.
I think just to give a bit of balance to it, David, not that you're not balanced, but to give a bit more balance to it, from my agency background, what I would say is, and again, my background is residential, not commercial agency, but I think sometimes some agents will do it deliberately, knowing full well that it's greenbelt or whatever. Some agents will do it just out of carelessness and lack of lack of research, lack of knowledge. They'll just put it out there, and others are just doing it because they think that will improve the marketing opportunity for the site and it will give them a chance of selling it. So it's just a case of buyer beware, very much a case of buyer beware with these things.
That's right, yeah. I mean, we're not talking about misrepresentations here. We're talking about people trying to put the opportunity for the site at its highest, and it's obviously, as you say, it falls on the shoulders of the potential purchaser to do this, to check this due diligence themselves. But one shouldn't get carried away with the way it's phrased sometimes in marketing brochures. There is an element of marketing puff to it, and you have to put that in context.
Often it's one-dimensional. It's based on the size of the site, what it could technically allocate.
Yes.
There's space for 200 units.
Exactly, and that's exactly how they're looking at it. They're looking at it in a physical sense. That doesn't necessarily mean that they've picked up the phone to an officer, they haven't done a pre-app, they haven't done any of this. This will fall on the shoulders of the purchaser, and it's buyer beware, as you say.
Fine. So our first common mistake is don't trust the agents, or more specifically, beware of development potential as described in a marketing brochure.
Just check everything yourself. Absolutely. Okay. Yeah.
Right. Should we move on to our second one, David?
Well, the second one is in terms of local residents, and don't underestimate local residents. There have been a number of instances where we have had to deal with local residents several times over. I'm dealing with a planning application at the moment for about 114 units in Farnborough, in London Borough of Rushmore. And we've had a public exhibition with residents, but not all of the residents turned up to that public exhibition. Right. And so we were asked by the council to do another one-on meeting with the next-door neighbour residents. There's a particular block which is right next door to our particular site. So because it was felt that the public exhibition might have missed some people off the list, perhaps people were away on holiday, we were asked to do a follow-up meeting with them. And then after that, it so happened that there was another meeting that had to be had because a number of residents who were on the management board for that block were away on both the previous occasions, and they'd raised problems since. And it's a very difficult fine line as to how much you're going to kowtow to the council and provide them with more and more input from the residents. This is where it's very important to build up a relationship with officers at an early stage through pre-app, providing thorough information, accurate information in reports, and building up your credibility as the applicant with the officers. Because it can get to a point where, quite frankly, the residents are being unreasonable, and we've got to this point now in this particular application, and because of our relationship with officers have said, well, actually, we think you've sort of done enough, really. What you've done since has probably tipped us towards perhaps supporting the application.
Really?
So we haven't got their formal go-ahead yet with it, but it's a very complicated application for obviously a very large development. So we've had to jump through a number of hoops with it. Also, because with such applications, for large applications, you have to provide a suite of documents: air quality management assessments, transport assessments, flood risk impact. The list goes on and on. Even structural surveying information as well. You've got all this information. You've also got to provide a statement of community involvement to show that you've approached the locals, you've had a dialogue with them, you've listened to them, you've picked up on those local issues. And it's particularly relevant at this point in time as well, because we're coming into local elections. And so what we're entering into is what's called a period of purdah. Basically, there is no informal communication between some officers at senior level and council members in the run-up to the local elections, because the councillors don't want to say anything that perhaps leaves them on the hook and susceptible to their constituents for saying, well, you said that this was okay to the officer and therefore I'm not going to vote you in at the next local election. So committee members and councillors are being extremely careful about what they say off the record. Everything's on the record, and obviously with anything on the record with council members,
it's the official line. What they're
it's the official line, and so you're not really going to be able to move very far forward with complicated political or controversial applications in this purdah period, unless you've got all that tied up well in advance in any event. So that's something that we've been warned about by this particular local authority we're dealing with down in Farnborough. There are other applications as well where what we're doing is we're working behind the scenes, continuing to work behind the scenes with officers to build that relationship so that we're ready to go in with an application when we get past the local elections. Obviously, monitor what's happening at the local elections to see whether or not there's a swing between one constituency party and another.
Right.
And that may make a difference to what happens with your application in future as well. So it's a very hot topic right now in terms of the politics of it, working with the locals and having to deal with purdah periods.
That's really interesting. I had not been familiar with that purdah period issue. Is it mainly for the larger development, the larger applications that will be a problem, or does it affect everything?
No, it can affect some smaller developments as well.
Is it anything that will go to committee, really?
Well, I tell you what's been going on. We were told by a senior officer that we spoke to, that there had been a third party, we don't know who, and we don't know whether or not they were related to any of the constituency parties, who were going round knocking on the doors of residents in the locality, asking them generally if there were any problems that they'd experienced with the local authority, any complaints they wished to make, they had made, and they wanted re-investigating.
Right.
And this is an absolute pain in the arse for officers. They're trying to get down to the application that you keep on badgering them about every week. They are genuinely trying to deal with it, but then they get enforcement matters to have to deal with, and they get somebody coming back to them and said, well, actually, there was a complaint I made something like 3 years ago, and it's not been responded to yet. So they've got to go back in their files and back in their archives. It all takes time to do. And so it's all fun and games with local politics at this point in time.
Okay, so, I mean, it's quite interesting what you say about local residents, because I've kind of seen two very sort of broad-brushed schools of thought. One is, you shouldn't let one, slightly sort of, unhappy local resident spoil a perfectly good scheme, and you don't want to pander too much to them on one side. But also, the other side of it is, they can be a big asset if they are supportive of the application, or at least don't object. And maybe it's the right thing to do, and it's maybe good for PR as well.
Yeah. No, that's absolutely right. Actually, the meeting that we had, the third meeting that we had with the residents, we were realistic in our expectations. We pretty much knew that we wouldn't come to a final agreement with them. They effectively wanted us to be able to move the whole building back, and that was going to be the line that we were going to draw at. We were never going to agree with them on that. However, that was probably one of perhaps 5 or 6 objections. But all the other objections fell away after spending a few hours going through with them on an individual basis what's shown on the plans. Because sometimes they just can't read the plans and they can't understand the scheme properly. And you build up a relationship with residents. You take some of that hostility and that sting out of some of their objections. They may very well still object, but they'll object usually on fewer issues after you've had a time to sit down and go through it with them as well. I mean, basic things like they don't understand the difference between a green roof, where you can't have access only other than for maintenance, and a balcony. So they're completely misreading some of the plans.
Right.
And it's not unexpected. We're talking about schemes where they have to flick between sections, elevations and floor plans. And we're used to it, but they're not, and they don't deal with this on that basis, on an everyday basis. So sometimes it's about walking them through it and showing them what the proposals are, and then using that to try and put their mind at ease on key issues.
And perhaps just kind of general or customer service skills, giving them a good listening to.
Yes.
And actually then sort of, even if you disagree with them at the end, you've shown that you've taken their point into consideration.
Yes, yeah.
And you've thought about it.
Now, there will be developers out there who say, well, why should I do this? And it's just a waste of time, quite frankly. But planning officers want you to do it. You have to go through those hoops. Planning officers are often, sometimes planning officers are very helpful, and they will try and explain that to residents themselves. It so happened in this particular case, our planning officer, who's a senior planning officer, didn't want to, because he didn't want to be seen to be advocating the case for the applicant.
Right.
That was our job, to put those representations to them. So he relayed to us what he saw were the issues and the problems, and said, right, you'll need to go in, you'll need to discuss this again with them, and you'll need to walk them through it. And they were very grateful to us for the fact that we've done this again and jumped through it.
This is the officers?
This is the officers. They were very grateful to us. So it's about building up that credibility and that relationship. I think that was key to them going from a position that, well, we see a whole grey cloud in relation to this particular part of your development, this particular elevation, its relationship to the neighbours. However, if you go back and speak to the residents again, and you can narrow down some of these issues and see where we get to, then we may be able to support you. And then we came back to the officers and they said, well, thank you for going through all of that. We now understand where it's distilled down to, and we need to go away and consider it, but we feel a lot more comfort about these issues, and we feel we're able to sort of tip the balance, and that tips the balance, and now we're able to move forward with the application. So it can make a difference.
So in short, don't underestimate the residents.
Don't underestimate the residents, yes, yeah. Okay,
and that's our second common mistake.
That's our second common
mistake. That
mistake.
leaves us with the third and final one, David. So put us out of our misery. What is it?
It's very much related to the first 2 points, and that is when the application goes in, what I often see is I see refusals coming to me. I have to deal with them on appeal. Why did it get refused? It got refused for reasons that could have been dealt with by the applicant during the application process. Somebody whoever it was, whether it was a previous planning consultant or it was an architect, they failed to project manage the planning application through. And that's exactly what it is. It's effectively, you are partly a project manager when you are an agent on a planning application. Don't put the application in and then forget all about it and think that your work is done, unless you really think you have no hope of getting this through on an application and dead set on an appeal of any effect. But in most cases, where they fail a planning application, they could have been saved by the agent maintaining regular contact with the officers and following through on the application. It's like a good golf swing or a good tennis swing. You've got to follow through on it.
Follow through, yeah, absolutely. Just where you say agent there, you obviously mean the agent in the application?
The agent in the application.
So the planning consultant or the architect? Not
a property agent like a Savills, someone like that, acting as the agent for the vendor. This would be somebody who puts their name down on the form, the planning application form, as a person for the planning officers to contact if they need to discuss the application. And often officers won't contact you out of the blue. There are a lot of times when officers are not very proactive about it. They have their other priorities. They may be dealing with different applications. When the application goes in, you need to make a diary note as to maybe 1 or 2 weeks hence, make sure it gets registered and validated, and then you make another diary note 3 or 4 weeks hence to make sure after the public consultation period you pick up on any queries with the officers. You're arranging a site visit. You're keeping them on a tight leash so that you can pick up on these problems and these issues early enough. I had one just this morning where we're dealing with a lawful use application. The officer has come back to us because I've been chasing her up, and she said, well, I need more evidence on this. If we hadn't have contacted her, she may have just refused the application. We'd been into an appeal. That appeal could take 12 months and would massively bump up the costs for our client as well. So we have an opportunity here to step in with further statutory declarations, further evidence, and hopefully basically steer it through onto delegated powers in 8 weeks.
Do pre-apps sort of come? I know you touched on them a little bit earlier. Do pre-apps form part of this? Because I know it does depend on the size of the scheme and how complicated it is, etc. But I see some developers who are very adamant they won't be doing pre-apps because they're not legally binding, because they're not, they don't have the weight behind them. They see them as a waste of time. And you see other people who say, I wouldn't put an application in for anything complicated without a pre-app because I want even if it's not legally binding, the council can go back on the statements and representations they've made. The idea is it's on the record and it's caused them to consider it and it's built rapport.
Yes.
What's your view, or does it really depend?
It is very difficult to say. In those situations where the pre-app seems to have not been worth the paper it was written on, they could be due to any number of instances. I had a recent conversation with somebody who said that they had a pre-app. It ended up being useless because the heritage officer wasn't consulted on the pre-app, and it was arguably something that could have affected the setting of a nearby listed building, and the heritage officer intervened during the planning application, and that steered it towards a refusal.
Right.
Well, if you know that your development was in the setting of a listed building, then surely you would be picking up with the planning officer who's dealing with a pre-app as to whether or not he's consulted his colleague in heritage as part of the pre-app.
Absolutely.
So there are instances where the pre-app could have been done better, but it's a matter of picking up on the issues and knowing what those issues are and making sure that they are integrated within the pre-app response. You do get officers who change as well. You can get inconsistency between officers. And I'm not going to pretend for a moment that the pre-application process is gold dust, and anything written in there, the council are going to hold. You're going to be able to hold the council to. More often than not, you're going through that process to build up a relationship with officers. It's probably going to be the same officers dealing with the planning application that dealt with the pre-app. Partly. Also, once you get into planning application, they tend to be more willing to negotiate with you on planning matters if you've been through the pre-app first.
Right.
Because they do see it as a bit of a developer's game, just presenting them with a fait accompli during the planning application. There's a whole load of problems, and you've shown no willingness, as they see it up to that point, so no willingness to try and negotiate with them or canvass with them as to what their opinion is. It's a case of, here's our application, we think it complies with planning policy and we expect a grant of planning permission. Rather than going to them more softly on the pre-applications, this is what we're thinking of doing, we'd be interested in hearing your thoughts for that.
And then the application you ultimately submit shows a little bit of...
It shows that dialogue, it shows that response.
Oh, they have changed the parking,
exactly,
or they have thought about the issues you raised.
Yes, yeah. They like to feel as also that they're getting something out of it. In the public interest. As
all negotiations,
exactly.
You want to see a win-win, or at least to see that there's been give and take on both sides.
Yeah. I mean, there are situations when, quite frankly, it's not worth going in for a pre-app. When you know, for instance, they'd be against it on the principle, because they've had a number of cases that they've considered before and they're against it on principle. But you think that you're going to get a fair crack of it, or a better crack of it, from a planning inspector. So you're not necessarily going to waste time on a pre-app, you're just going to try and take it straight to appeal. You don't want to waste time on the pre-app process. But I would not say that it's a complete waste of time doing the pre-app. It depends upon the quality of the submission, depends upon the size of the scheme, it depends upon your relationship with the officers at that local level, etc. So it depends on so many factors. You just can't say really one way or the other.
It sounds like you need to speak to a planning consultant before doing these things.
Yes, I think so, yes.
Because it varies so much.
It does, it does, yes.
So where's that leave us, David, with our third? Our third one is, treat it just like a golf swing.
Yeah.
Put your application in and follow through.
Absolutely, yeah.
So we'll do a really quick summary of our three things. So we had... never believe the agent was the headline, but I think what we're saying is check everything.
Yeah.
The information we're given before you start spending money on a site. The second thing was never underestimate the local residents. They can be your friend or they can be your foe. And sometimes how you treat them can determine to what degree which side they'll come down on. And the final thing is always follow through with your applications and treat it like a golf swing.
Yeah, absolutely.
David, I know you're so busy, so thanks very much for making the time to meet up today. David Kemp from the RK Planning.
Thank you.
Thank you very much.
Cheers.
Take care.